It'll be on the November ballot in Florida. Amendment 4, the proposed amendment to limit government interference with abortion. We heard a couple weeks ago from proponents of the amendment, and today we are going to hear from the other side. We've got Matt Staver, the founder and chairman of Liberty Counsel, and John Stemberger, president of Liberty Counsel Action. We take a deep dive into the Florida Supreme Court's recent pair of decisions on the abortion issue. One upholding a 15-week ban, which will set into effect a 6-week restriction on abortions starting May 1st here in Florida, and the other which allowed Amendment 4 to appear on the November ballot. So stick with us.
We're going to expose this amendment for what it is, the most extreme proposal that's ever been put forth in Florida's history.
You're listening to A Deeper Dive with Dara, a podcast by the News Service of Florida.
Good morning. Welcome to A Deeper Dive with me, Dara Cam. Today, I am very, very fortunate to have two special guests with us from the Liberty Counsel and an affiliated Liberty Counsel group. I want to make sure that I'm accurate because facts matter. Matt Staver, founder and chairman of Liberty Counsel, and John Stemberger, president of Liberty Counsel Action. How'd I do, guys?
Great, dude.
Okay, thank you. And we are here to talk about abortion rights today. A lot going on in Florida and around the country post Dobbs, and John, you and I have discussed this on many occasions. Matt, you probably don't remember me, but we have spoken over the years on other issues that you've been involved in, filing lawsuits. And I don't think they were all abortion related. But we most recently ran into each other outside, us and a couple of hundred maybe other folks outside on the steps of the Florida Supreme Court following arguments in the in oral arguments on what will appear as Amendment 4 now on the November ballot. So we're here to talk about the 6-week ban and the amendment, the proposed constitutional amendment that voters will weigh in on in November. Let's start with the ban, the 6-week restriction, I guess. And I'm using language that we use in media in AP style, and and John's smiling because he knows I want to be very respectful. I want to respect everyone's positions, and so when I'm not trying to use any pejorative words, so if that's okay, and if you want to correct me, feel free to correct me. So I just want to let everybody know where I'm coming from. 6 weeks is about to take effect May 1st. This has got to be a huge day of triumph for you all. Do you think the 6-week restriction goes far enough? It does have some exceptions. Do you support the exceptions? Let's start with you, Matt.
Well, I think what happened on April the 1st is a huge transition in Florida. Florida went from being the most, or one of the most liberal states in the nation regarding abortion because of the 1989 TW case, which was frankly more radical than the 1973 U.S. Supreme Court Roe versus Wade decision, because that case from the Florida Supreme Court referred to the fetus as a highly specialized group of cells totally dependent upon the mother for sustenance. And that's a very radical decision. And post-Dobbs, when Roe was overturned, Florida became an abortion destination when other states began passing pro-life laws. So we moved from that kind of very radical liberal position on abortion in one fell swoop with a 6-1 decision to one of the most pro-life states in the nation that upheld the 15-week abortion ban and then allowed the 6-week heartbeat law to go into effect by May the 1st. So it's a huge sea change that occurred in this one decision. So yes, it's 35 years in the making, and I think it will impact generations to come.
Do you think that, what's your position on the exceptions?
Well, personally, I have members of my family who are the product of rape and incest. Certainly, I favor a life exception because, whether you're born or unborn, life for life, which is a very rare situation when you actually have life for life. But in other cases, outside of that, I have 2 generations in my family where my father raped my sister. So, as strange as it sounds, I have a sister who's my half-sister who was raped by my father, who gave birth to what is also another half-sister, but also my niece. And she has given birth to another generation. So I have 2 generations that are from the sin of my father. I would never, and certainly the family would never look back and say, as bad as that situation was many, many years ago, it was horrible, it was awful, it was traumatic. Life always wins, and life is always the right choice.
I thank you for sharing your story. I don't know if I'm long in the tooth, and if I knew that story, I have forgotten it. So I appreciate you sharing your family history. So you do have a direct knowledge of the impact of these, what could be exceptions in some cases. John, that's not something that all pro-life folks agree on, though, is it? That there shouldn't be exceptions.
No, there's a lot of diversity of opinion within the movement. And first, Dara, I just want to stop by thanking you for having the show and for your commitment to classical liberalism, the free exchange of ideas, and really allowing all opinions to be heard on this podcast. It's really an unusual but a great thing in our society to have different viewpoints heard. But yeah, there's a lot of diversity of opinion, even within the pro-life movement. People advocating in different strategies, different ways. I think everybody agrees that our goal is to protect the most innocent human beings that there are, those human beings that are in the mother's womb. That's the goal. I mean, obviously the legal part is to ban the procedure which destroys them, but the goal here is to protect human beings. And so that's a perspective we want to bring to the table. And we're not just banning something, we're actually protecting the unborn child, which is to us is the most innocent human being on the face of the earth.
Okay, I knew you were going to catch me on bans, so I set myself up for that. Thank you. Some doctors, I was speaking with a doctor on this issue recently on the podcast, and she was saying that there, with these exceptions, that you have to have 2 doctors to say that the life of the mother or the is at risk. And that doctors now are getting too nervous. They're afraid of being investigated. They're afraid of putting their names on those certifications. Is that sort of part of the reason behind requiring 2 doctors? I mean, that seems like that would be an outcome that would suit you.
So in the event of an emergency, the statute says that only 1 doctor can.
That's right. If it's a life-threatening emergency, yes. But in other cases, it requires 2 doctors.
That's correct.
But it seems like, when you're talking about life and death, 2 doctors is an appropriate situation because you can have, I've done lots and lots of depositions of doctors over my years, decades of practicing law. And certainly in this area of abortion, you can have someone who just simply carte blanche says the life of the mother and would do that all the time. And if there's no additional medical opinion to that to balance it out, then you simply have a doctor that has a veto right over any kind of law that's passed, in this case, the heartbeat law. So I think the second opinion is a good one.
What do you say about arguments where people say, like, you're placing the life of the infant above the life of the mother?
Well, I think that, take that into the situation of a newborn baby. And, if you can't make that same argument that say, well, you're placing the life of the mother subservient to the baby or vice versa, then move it back in gestational time. I think that the argument doesn't hold water. There is no life that's being placed above the other. There is a medical determination as to whether or not there is a life that's in jeopardy at this stage, because the decision is a terminal one. And that decision would be to terminate a baby who is a human being from the moment of fertilization. That has to be taken properly in consideration with all the facts and circumstances from a medical situation. So the medical doctors will have to evaluate those situations on a case-by-case basis.
And to your mind, when does life begin?
I think there's no question that life begins at the moment of fertilization. We just did an article recently, and there's a well-known medical journal that's used today in medical schools, and I found a 1975 version of it, and it says human life begins at the moment of fertilization. This is 2 years after Roe versus Wade, but that same medical book that is used in medical schools, the Langhorne medical book, has been used from the early 70s. It's clear from a biological and medical standpoint that life begins at the moment of fertilization, where there's a unique human being that's created at that very moment.
How does that fit in with the argument against IVF then?
We actually did an article on that with regards to the Alabama Supreme Court. The Alabama Supreme Court got it right that life begins at the moment of fertilization. From a scientific standpoint, that's really not debatable. The Alabama legislature, in a knee-jerk reaction, got it wrong, where they gave liability protection to the IVF clinics. What happens in the IVF clinics is mass production, and there's not a respect for the human life that's at issue. So they do mass production, and they will destroy or they will use for experimentation or put in cryogenic freezers the majority of the fertilized eggs. I have a friend, for example, an attorney, he's very pro-life, lives in Georgia, was not able to have children. She and her husband went to an IVF clinic, and they told the clinic that they're very pro-life. They don't want to do mass production and destroy or cryogenically freeze eggs for however many years. I mean, amazingly, just last year, the oldest frozen human embryo was implanted and were born. They were twins, brothers and sister, 30 years in a cryogenic freezer, born in a mother who was 33 years of age. She and her husband implanted them. She was 33 when they were born. They were 30 years in the cryogenic freezer, and they were born last year. It was recently published in major newspapers and articles just recently. But what she did was she said to the IVF clinic that rather than fertilize a lot of eggs at once and then cryogenically freeze or destroy the residual, she wanted to do it one egg at a time, and they agreed to do it. And she did one egg at a time, implanted one egg, fertilized one egg, implanted that one egg. Her and her husband are now the parents of 4 very happy, healthy children that were born through IVF, but were not done in the typical IVF fashion where there is no respect for human life. IVF can be done in a way that it respects human life. And frankly, the IVF clinics here in the United States have far less regulation than many IVF clinics around the world. So I think it's an opportunity for us to actually look at the process, not stop it per se, but to provide restrictions or regulations that would protect the innocence of human life while also birthing human life, as in the case of my very good friend.
Do you think this is something that the legislature, like, is this legislation that you all are going to pursue with the Florida legislature?
I'll let John address that.
There's no plans right now, but it's certainly something that we need to look at. This is a serious ethical issue, and it's something that has to be addressed. I'm not aware of any bills, though, that are being filed.
It's kind of divided, though. The Republican community, I guess I'm not sure about the pro-life community, but Republicans were split on it. As you yourself mentioned, Matt, the Alabama legislature quickly moved to undo or to make sure that IVF was still available after that Alabama Supreme Court ruling.
Yeah, I think that what has to occur is some rational, thought-out process rather than a knee-jerk reaction or a popularity contest. Because on the one hand, you have this popularity contest that they felt that they were a part of, and they wanted to satisfy what they felt were the political wins to not stop IVF. But they didn't take time to actually research what happens in IVF and how IVF can be done in a way that respects the sanctity of human life, and how, frankly, IVF is done much differently here than it is in other parts of the world. Other parts of the world have much more different regulations than we have here. In the United States, it's sort of like the Wild West with very little regulation. And the Alabama legislature made it worse because what they did was they essentially gave a legal immunity to the IVF clinics. That's not the way that you should address this. There are ways to address it where it's not necessarily an either or, but we need a rational discussion so that all of the parts and pieces are on the table and we decide what's the best way to move forward.
With our 6-week protection going into, I'm going to get a bunch of emails on that, I can guarantee you, going into effect. I have a couple of practical questions. I don't know if you all are, and then we want to get into the legal stuff soon, I promise, because I'm nerdy. I won't be able to out-debate you all, but I do have some questions, and I know that you'll be able to answer them. But before we get there, does the 6-week law, does it ban the morning after pill? Do you think we're going to be seeing a rush for medication assisted abortions?
John, you want to address that?
You can take that, Matt.
Nobody wants it.
Here's an example, Dara. There was a local news station up in New York that recently did an interview with a local New York abortion facility. And this particular one is protected by the SHIELD law that New York passed so that they can do telemedicine. After they started to do the mifepristone, they started to market this. They were doing 4,000 a month. When they did the actual interview, they were up to 10,000 pills a month. 10,000 pills a month that they were sending out of state, mostly into what they said blue states, which had more pro-life laws. And they specifically mentioned Florida and they mentioned Texas as some of those states where the bulk of their 10,000 per month. And that's just...
Well, I need to step in and say Florida and Texas are far from blue states, but go ahead.
Well, they said blue. They used the word blue.
Okay.
I get your point.
Yeah.
I'm just what the person that was being interviewed
right.
said, and they mentioned Texas and Florida. So they were targeting intentionally states, and this was before TW was overturned, that they felt were more restrictive, although Florida would not have been in that category at that time. Now it is. However, so now, the FDA has approved this for up to 10 weeks. So that clearly goes beyond the 6-week bill. So I think in that case, at least between week 6 or so and week 10, yes, I think it would violate. And I think there's an intentionality to try to violate these laws of states, whether it's Florida or some other state, with the mailing of mifepristone. The case is at the U.S. Supreme Court now. It may just be decided on standing, so they might not get to the merits of the issue, but the FDA knows that mifepristone between, I think, September 2021 to 2022 or so resulted in about 3,900 adverse events, including deaths. And they also have acknowledged that doing mifepristone telemedicine-wise without an in-person visit increases the risk of adverse injury from mifepristone. So it is an issue I think the legislature will have to consider, but certainly I think after 6 weeks, which is generally the time that you're going to hear a heartbeat, with mifepristone being authorized at least now up to 10 weeks, I think it certainly would be a violation at that stage for one of the later 6 to 10 week abortions.
Yeah, so for chemical abortions, that's correct what Matt's saying, but you asked specifically about the morning after pill, and that's, if you're talking about literally a morning after, then no, it wouldn't prohibit any of those abortifacient drugs that are under 6 weeks.
So the morning after pill not affected, anything under 6 weeks not affected.
Should not be, no, and not.
Should not be.
Yeah,
Yeah, and women would be able to leave the state. I've heard of other states where they're trying to keep women from leaving the state for a procedure, and nothing in Florida law or no Florida leaders that have said that that's going to be an issue, right?
Well, no, I mean, you have just the right to travel, the right to move freely, interstate commerce. I mean, I don't see any legal ability to prevent that from happening, unfortunately.
Okay, let's move on to Amendment 4, which prohibits, geez, you'd think I would have this up on my screen and I don't, but it limits government interference in abortion, I think is the name of, it's the name or it's close to the name, and it specifically mentions viability. You all very familiar. You were arguing against the amendment, Matt. So give us a idea of what you were trying to convince the court of during those arguments.
Well, the actual language, and I'll tell you, there are two real legal issues that are at play here. It says no law, which is quite broad, shall prohibit, penalize, delay, or restrict abortion before viability, or when necessary to protect the patient's health, as determined by the patient's healthcare provider. So under that particular provision, there's no law other than parental notification that will stand prior to viability, which is not determined as to when that is, but it could be certainly late second, early third trimester. Or after viability, as determined by the patient's healthcare provider to protect the patient's health. So the healthcare provider is not defined either. And we've filed a notice with the Florida Supreme Court that there's about 58 different categories of healthcare practitioners or providers that include people who have no medical training whatsoever. And those would include a 911 operator, an orthotic fitter, an assistant to an orthotic fitter, a tattoo artist, and the list goes on and on. So those individuals are included in what a healthcare provider would be under this provision. And they would be able to make a determination as to whether or not the baby is viable, and even if it is viable, whether the abortion is still necessary in a late term scenario to protect the health of the mother. And yet they have zero medical training. If this amendment wanted to limit it to doctors, licensed medical doctors, they could have referenced the section of the Florida statutes that specifically refers to licensed Florida doctors, MDs, DOs, but they didn't. They left it undefined. So our argument was twofold. One, that in order to have a voter initiative, and there's 4 ways to amend the Constitution, the voter initiative is one of the 4 ways. That particular provision of the Florida law requires that the voter initiative be clear and not ambiguous, so that it's unambiguous, so that the voter knows what their yes is and what their no is. The voter's not going to know here by saying yes that this is essentially unlimited abortion except for parental notification, that all these laws will be overturned, that there's no parental consent, no informed consent, because that could delay an abortion. There may not even be any clinic regulations, because even when we litigated for years at the Supreme Court under Roe, even health and safety regulations were challenged as being an undue burden to abortion. And so those things will be challenged as well. The average person, no matter how far you are on the spectrum of being in favor of abortion, would not be in favor of unregulated abortion, particularly no health and safety regulations, no informed consent, and so forth. So they wouldn't know that. It's deceptive. And in fact, the title says that it prohibits government interference. Actually, it disables government. All three branches, neither the legislature nor the courts, nor the regulatory body under the executive branch would have the ability to do anything to protect life. And then the other thing is single subject.
Wait, before we get to single subject, can I ask you about that? Because couldn't the legislature change the definition of what a healthcare provider is to just be like a nurse practitioner or a doctor? Is that something they could do?
Yeah, Dara, that's an excellent question, but here's my take on it. So assume this is on the ballot and assume it passes in November. And at that time, what's in current law is 58 categories that have the opportunity to give an opinion.
Well, unless the legislature fixes it now. Before,
with a special session.
Right.
But say it passes, now you got 58 categories. Now you limit it down to just licensed medical doctors. Well, my goodness, you've just now reduced 57 categories, and now you have one category, which is your licensed MDs and DOs. What's the argument from the other side? You've just restricted or penalized abortion. You've just placed a limit. You've restricted abortion by limiting the options of healthcare providers. And so I think that would have to be done before the passage of this initiative.
Okay, so legislature, hope y'all are listening. I know the Senate president and the House Speaker do listen to these podcasts. So, and other legislative leaders do. I hear that I am the walking buddy of at least one or two state senators. I won't name them. I won't embarrass them.
I'll tell you something that's kind of funny, but it's really not funny when you put it in this context. In 2021, a septic tank contractor was category 59, I believe it was. And the legislature moved the septic tank contractor out under the Department of Environmental Protection. So as of then, they're still listed as one of them when you go to the Florida website. But when you click on it, it actually takes you to its current new section, which will be in the Department of Environmental Protection.
So, Dara, if I could just weigh in for a second.
Sure.
The problem here is that when you enshrine a fundamental right, which is what they would be doing, you're basically, it trumps everything else. So all of the health and safety regulations designed to protect women are gone. Parental consent is gone. The reflection period, the 24-hour waiting period, it's all gone. And so we've seen in other states when radical language is proposed and is adopted that the courts have to abide by it because it can't meet the strict scrutiny standard. So basically that's the problem with it. It starts out appearing to be very reasonable, talking about viability. We're not even sure what that means actually, because it's a moving target. But then it talks about the health of the mother. And the companion case in Roe versus Wade was Doe versus Bolton. It was a hospital case discussing the concept of health. They used the UN broad definition of health. So any nausea, vomiting, headache, any symptom of pregnancy becomes a health issue. So it's basically abortion on demand for any health reason, which makes it entirely radical. Justice Renata Francis, in her dissent, in the opinion, said the summary hides the ball as to the chief purpose of the proposed amendment, which ultimately is to do, for the first time in Florida history, grant an almost unrestricted right to abortion. And so this is the problem with the amendment. It's deceptive and it's radical. And I think when the average voter finds out, look, people have different views on abortion in Florida. That's clear. Even though we're a red state and we have 900,000 more Republicans than we do Democrats, they do have different views. But when they find out how radical this is, when we communicate that, I think they're going to vote no on Amendment 4, and that's what we're hoping.
We have a new email address, and we'd love to hear from you. To reach us and give us your input, tell us what you'd like to hear. Tell us what you thought about what you already heard. Tell us how fabulous we are. Join the Deeper Divas team. Send an email to podcasts@e.newsserviceflorida.com. That's podcasts@e.newsserviceflorida.com. And I promise I will read everyone. And so you're bringing me, I do enjoy it when my guests, when the podcasts unfold organically, as they always do when I'm with you, John. And you're bringing me now to one of the questions that I had, and that is, we know there's going to be an active Yes on 4 campaign. We'll talk about potential litigation in a moment, but let's talk about the politics of this amendment first. Who's going to be leading the charge? I know there's many different groups, pro-life groups, that were very upset about this amendment going on the ballot. So who should I be looking for? What's the name of the committee? Who's organizing? Who's going to be working? Yeah. And that's inquiring mind here wants to know.
Yeah, so Florida Voters Against Extremism is the formal PAC for legal purposes. And so there'll be a large coalition of organizations, and they're all working together for a common purpose, supporting the PAC. There's a physician out of the West Coast, a woman who is an OBGYN who's retired. She's the chairman of the PAC, but there's going to be many voices speaking to one goal, and that's say no on 4.
And you've been involved in multiple ballot initiatives before. They're a lot more expensive nowadays. I think the pro side spent at least $20 million just getting past the signature phase. How much do you think that this campaign is? How much do you think that Amendment 4? How much money do you think is going to be spent on this?
Well, I'm not going to speculate on that. There's going to be quite a bit of money, millions of dollars spent on both sides.
Yeah. Dr.
Mary J. O'Sullivan is the person,
okay,
the physician who's actually heading the committees, the chairman of the PAC.
Okay.
But yeah, there's going to be a legitimate campaign. There's going to be TV, radio, grassroots. We don't need to raise as much money as the other side do, but we will raise millions of dollars, and we will fight this and defeat it. In Ohio, there was only a 59% vote, which they had a 50% hurdle, so they won. The pro-abortion rights people won there. But in Florida, we have a 60% hurdle. That's really high. And so we think that we're going to be able to defeat this pretty clearly.
You have a 60% hurdle, and you also have President Trump and President Biden. You know, there's a lot of talk in the media, not me, but other outlets, sort of a lack of enthusiasm on the Democrat side about President Biden. Abortion it's not partisan overtly, but I think it's safe to say that more Democrats might support it. People left of center might support the amendment than those who are right of center. Do you think that kind of lack of enthusiasm at the top of the ticket is going to affect the ability to get that amendment over the 60% threshold? Or do you think that the abortion issue that people feel very strongly about is going to drive out turnout and help the Democrats?
Well, that's what they're counting on. This appears to be their number one issue. The problem is this polls very differently when you help people understand the nature of what we're talking about, right? When they understand that you're going to strike down parental consent, you're going to strike down the waiting period, the reflection period, health and safety regulations to protect women. That's crazy stuff. I mean, the average voter is not going to like that. We're going to expose this amendment for what it is, the most extreme proposal that's ever been put forth in Florida's history. And so I think when that happens, you're going to see this matter being defeated, and it's going to motivate people on both sides. There's apathy on both sides of the ticket, but this will motivate people. But when they understand how radical it is, I think we get the advantage, because it's not what it appears to be at all.
Speaking of apathy, you, Matt, issued an interesting press release a couple of days ago saying politicians should stand for life, not run from it. The right to life is the right of all rights, without which there is no other right. Life is the preeminent right and the foundation of all rights. And you go on, and I believe that this is a recently some politicians have demonstrated poor thinking as they try to determine the political wins. They are like the parable of Jesus, where the seed was sown on rocky ground. When the winds and the heat come, the seed sprouts, but soon withers because it did not have deep roots. I felt like those comments were directed towards President Trump, although you did not identify him by name. Am I wrong?
Well, you're not totally wrong, but it wasn't directed toward any one particular one. However, recent events happened with President Trump, as well as Kari Lake in Arizona, and even post the overturning of Dobbs. There was a lot of Republicans that were in favor of overturning Roe versus Wade, and then when Dobbs was overturned, they were silent. So, with the recent comments that became very well publicized by Donald Trump and Kari Lake, I felt it was time to create a line in the sand, because what has happened, if you look at Florida as an example, take a look at Governor Ron DeSantis. Governor DeSantis has not run from this issue. He's run for life, and he's not run away from it. So he articulated it. The legislature really hasn't changed significantly. It was Republican in the House and the Senate. What did change was a leader in the governor's mansion, and that was Ron DeSantis. And as a result of that leadership was able to learn and discuss these issues in a fundamental way and articulate it to the people. And John just mentioned, Ron DeSantis was originally elected by about 30,000 votes, very thin majority margin. And then in his second election, it was a landslide, to where now nearly 1 million more Republicans are registered in Florida than Democrats. How did that happen? It happened because Ron DeSantis articulated a message and didn't run from it. And that includes the sanctity of human life. And I think that's an example for all politicians. And we need to stand for human life because it is the right of all rights. Without it, the right to religious freedom, freedom of speech, the right to property, no other right is meaningful to a corpse. The right to life is the fundamental right of all rights.
Again, love it when this happens, because you lead me right up into what I wanted to dig into next, and that is what happens next with the litigation. And I'm looking at the Constitution. This is something that the Chief Justice Carlos Muniz, mentioned, and he pointed repeatedly to the Florida Constitution, Article 1, Section 2, basic rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and defend life and liberty. Should I read the whole thing, or should we just stop right there? Because I think we got it right there.
You got it right there, Dara. And there's also Article 1, Section 9, which also says a person has the right to due process.
That's right.
So during the argument, as you know, the Chief Justice brought up that issue and said he wasn't as concerned about what the ballot summary said, but he was very concerned about what it didn't say. And it didn't apprise the voter that this amendment, Amendment 4, would potentially have an impact on existing rights here and whether this would actually include the unborn. And you were there, you heard the argument. I thought it was a very good argument. We filed after that, Liberty
It
Counsel
caught the
did.
state attorney general's office flat-footed, oh, by the way.
Yeah, I know. I was there. And I got up. I had only 5 minutes. It ended up to be 6 minutes. I was able to raise at least a message
Yes.
that I agree with the concern. Then 2 days later, day and a half later, we filed with the Florida Supreme Court a supplemental filing. And in that filing, we give a summary of criminal statutes, tort statutes, guardianship statutes, and wills, trust, and estates statutes. And those go back for many, many years. And for example, in every one of those, the Florida legislature has for decades and decades used the word unborn child or unborn person in all of those categories. And for example, in criminal law, if you kill a mother that's pregnant and also kill the child, you can be charged with not one, but 2 homicides. If you cause damage, you can also be civilly sued because of damage to the unborn child. If an unborn child's in the womb, for example, and sometimes it's referred to as an unborn person, and somebody dies and there's a trust or an estate, a will, and it goes to the children or grandchildren, for example, those children that are born have a legal right to the disposition of those proceeds, but also the child in the womb has the same legal right, and you appoint a guardian ad litem to represent that unborn child or unborn person. They have the same right. So the question then is the word person as it's used in these statutes for decades different than the word person in the Constitution? And the answer, in my opinion, is no. So the Chief Justice had it right. I wish at the end of the day, it would have been enough to push the 4th vote over so we wouldn't be in this situation. And I was hopeful that it would, but unfortunately we know it. He raised the question, he even raised it again. But here's the thing, Dara. Whatever happens, I think there's potential legal challenges before a vote. I think there's potential legal challenges with how the signatures were gathered, whether there's sufficient certification in the various areas of the state. But even if it is on the ballot and there is a vote, I think that there could be a case now, but certainly there could be a case after. Take this for an example. The Amendment 4 passes in the worst case scenario from our position. Now it goes into the Constitution. Then there's these existing laws. They're not going to be just moved out by the legislature, but they'll be challenged. So you have a healthcare law or a parental consent law challenged. Now the defense to that is what? Well, the defense to that is Article 1, Section 2, thus allowing the Florida Supreme Court for the very first time to address personhood that's already in the Florida Constitution. So I think that's where these challenges can come up. And I think they certainly will. And it's certainly something that we would be attentive to.
So you would then file a lawsuit challenging the parental consent law, or you're assuming that the other side, the pro Amendment 4 folks, are going to be filing litigation to get these laws removed from the book, saying that they violate the amendment? Or
I think there could be both. Either they file a suit, in which case the state would be the defender,
Right.
and then we would have to try to intervene or do an amicus brief, or alternatively, to file on behalf of the unborn. For example, we filed on behalf of the unborn child, and we got a 2-1 decision out of Court of Appeals under TW. And it was a situation down in South Florida years ago where a late trimester baby was going to be aborted, and the incision was going to be exactly the same thing, hysterotomy or hysterectomy in that respect, sort of an abdominal incision. The only difference would be giving the baby some kind of poison or injection before or not, either giving birth to a live baby or a dead baby. And we filed a motion back then under TW for guardianship on behalf of that child. We got a 2-1 decision out of the Court of Appeals. I think now doing something like that, now that TW is overturned, and with what the justices have said in their dissents and in the majority opinion of these 2 cases, I think we have a strong argument that just like in the wills, trust, and estates, a guardian should be appointed. Why? Because this is an unborn child that's entitled to legal recognition.
So you think that the 4-3 would be flipped because you would have more robust arguments about the life of the unborn child and the due process. And so what we're really kind of looking at then, if this were to pass, is what you're, to me, in my mind, it's like a constitutional conflict, right?
Right, right. Because we know right now, based upon the dissents, there are three that have already essentially indicated their thinking in one way. But there's also a fourth one who was in the majority, who raised the same questions during oral argument and also in his opinion. So I think that we
Well,
could
that's the
have
Chief Justice.
the Chief Justice. So I think we could have a 4-3 or higher split on the Florida Supreme Court regarding personhood with the existing constitutional provisions.
So, Dara,
Yeah, I was just going to ask you.
voters do not see the actual language of the amendment. They see the summary of the amendment. And the policy reason behind that is because sometimes the actual language contains legal jargon that is not fully understood by the average voter. So they want the summary, theoretically in layman's words, to reflect the actual purpose of the amendment. Here, that's virtually identical, which is one of the reasons why the court looked at it and said they thought that it was not misleading, because the comparison is between the summary and the actual language. Now, the reason that the Citizens Initiative goes through the single subject process is because it uniquely is proposed by citizens who are not necessarily lawyers, and there could be conflicts between various parts of the Constitution. There could be log rolling, and they could create this legal mess. We will argue that is exactly the case, and that's exactly why Justice Munoz made this argument. So it would be highly unusual and historic for after the amendment is actually passed to challenge it internally within the Constitution. That would be a case of a first impression, I think, but it's possible and could be done given the scope of what we've been talking about.
So, but I mean, we are going to see litigation over this if it passes. And you're saying even, Matt, if I heard you correctly, we might even see litigation prior to November about the methodology that was used to gather the signatures.
Yeah, that's right. I think that's a possibility. We've been looking at that now. I know firsthand secondhand, but people that are part of my friend circles, that they were approached by petition gatherers, and they were never told that this was about abortion. One of them had to ask 3 times and finally got the word abortion out of the signature gatherer's mouth. So people were told about this. Of course, they're not reading the language. They're told that it's about women's health, protecting women's rights, but nothing about abortion. So I think a lot of people signed this not knowing what they were signing, and clearly not knowing the implication of what they were signing.
Before we finish, is there anything else that you'd like to add about the litigation?
No, I think that covers it.
Before we finish up, and thank you guys so much for joining me today, Arizona's court upheld and don't roll your eyes, but I feel obliged to ask because this happened quite recently, upheld what I believe is a Civil War era law that effectively bans abortion altogether. The law was on the books before Arizona was a state. Do you think that this will help boost support for the amendment, or do you think it is relevant at all?
It's not relevant to Florida. It's an Arizona law. It wouldn't have any jurisdictional effect in Florida, perhaps persuasive in some court or something, but no, it's not going to have any direct effect on Florida's politics.
Any wrapping up thoughts? Anything you'd like me to, that I didn't ask that I should have?
I just want to say to the woman perhaps who is perhaps abortion minded, listening to this show right now, considering this, that we can love them both. Adoption is always the better option. And we really have to compel women to understand there's no financial reasons. There's so much finances, Medicaid, there's pregnancy centers, there's all kinds of funding that are available to women that want that they're in this situation and perhaps want to abort the child and destroy it just because of financial reasons. So there really is a lot of care that can be had by real human beings and by public funding, by private funding. So that should never be a reason to have an abortion.
I just want to, I'm sorry.
Sure, go ahead.
I wanted to follow up with you, Matt. I was, just, or you, John, your situation with the rape and incest, it worked out well for your family with carrying that child to term. For many victims of sexual abuse, rape, or incest, their experience is so horrific that they might feel that there's no way that they can ever love that baby. They don't want to have that as part of their body. It is, a constant trauma to them. What do you say to those women?
Well, certainly, obviously, compassion. I'm not in that situation and can't even begin to associate with that, other than what I know personally in our family, and with my sister. James Robison, for example, a well-known pastor and a humanitarian in Texas, was a product of rape. And, his mother chose not to abort him. His mother was raped by an alcoholic, and he was conceived. Good friend of mine with a worldwide ministry. So, I always, obviously this is a very traumatic situation, but life, when you terminate it, you can't reverse it. But time has a way of healing. And certainly in our Christian perspective, there's forgiveness for whatever we do, but there's also comfort and healing in Jesus Christ. And consequently, that person may not want to keep that baby, and certainly that's understandable. But the child's a human life, notwithstanding the circumstances of its conception. The question is, how do you best deal with a tragedy like that, a horrible tragedy? And I believe that compounding it with another tragedy that is lifelong, the termination of a human being, does not help that initial tragedy. It compounds it. Life always wins at the end of the day. But I don't think that we ought to just throw it out as just this, exception. It's a very rare exception anyway. It's very rarely done where it's actually used. So it's a minor part. I mean, even if you had a life, health, and life and rape and incest exception, it's a very small number of abortions.
And I would just add to that, Dara, is that, well, obviously rape is a horrifically violent and brutal crime, and it should be. You don't compound the violence of rape with the violence of abortion. It just doesn't make sense. The compassion option is that adoption is always the better option in this situation if the person does not want to care for the child and give birth to it. I mean, we have literally tens of thousands of mothers and fathers who have been qualified to adopt, going overseas to adopt children. So there's no shortage of parents who want to care for children. There's even quiet waiting lists for Down syndrome children. So any child can be adopted that is an infant. Now, not so in the foster care. There's a huge need in foster care with adult children that have behavioral issues and have been exposed to drugs and that kind of thing. But in terms of newborn children, we can adopt those instantly and save them.
Well, Matt Staver, John Stemberger of the Liberty Counsel and Liberty Counsel Action, two gentlemen who know a lot about this issue and have invested a lot of time on this issue. I really appreciate you joining us today.
Thank you, Dara.
Thank you, Dara.
A Deeper Dive with Dara is hosted by Dara Cam, produced by Ryan Daly, and music for the podcast was recorded by Periodic Labs, LLC, and performed by Ryan Daly and Danny Reyes.